When a spouse dies, what does the surviving spouse inherit? As with most legal questions, the answer is it depends. I'm Daniel Hunt, a certified specialist in estate planning, trust, and probate law. If you're a surviving spouse trying to figure out how much of your deceased spouse's property you stand to inherit, there are numerous factors to consider. In this video, I'll be sharing a few of those. What does a surviving spouse inherit in California? In the community property state of California, the surviving spouse is entitled to at least 1/2 of any community and quasi-community property accumulated during the marriage. Factors that may impact this percentage include prenuptial or postnuptial agreements. If the couple signed a pre- or postnuptial agreement that outlined a different percentage than the standard 1/2 of community property, this will change the amount the surviving spouse receives. Estate planning document. If the deceased spouse created an estate plan, such as a will or a living trust, these documents contain information concerning the distribution of the spouse's estate upon their death. According to these documents, their spouse may receive more or less than the standard 1/2. Beneficiaries on life insurance policies, retirement plans, and or payable on death accounts. Retirement accounts, life insurance policies, and payable on death accounts, also known as transfer on death accounts, all require the owner to list a preferred beneficiary. This is called a beneficiary designation. When the owner dies, these assets are transferred directly to the listed beneficiary. What if a spouse dies intestate? When a person dies without an estate plan in place, this is called dying intestate. Their assets may need to be distributed by the California Probate Court according to the laws of intestate succession. Under these intestacy laws, the surviving spouse is entitled to 1/2 of all community property. Community property is any asset acquired by a couple while married, except an inheritance or a gift. A surviving spouse is also entitled to 1/2 of all quasi-community property. This refers to any asset that was acquired by one spouse in another state that would have been community property had it been acquired in California. Finally, the surviving spouse may be entitled to all of the deceased spouse's separate property if the spouse had no other living relatives. If they only had limited living relatives, the surviving spouse may also be entitled to part of the separate property in the probate estate. For example, if the decedent only had one child, the surviving spouse would get 1/2 of the separate property. If the decedent had more than one child, the surviving spouse would get 1/3 of the separate property. For help navigating estate administration, consult a probate lawyer for legal advice. One question many surviving spouses may have is who inherits their spouse's real estate. Check the title on the deed. Here are a few common ways title may be held. The decedent as trustee of their trust. If the house title is held in a trust, the decedent created a loan, then the property will be distributed as outlined in the decedent's estate plan. If they created a trust with their spouse, then the surviving spouse will take over as trustee and continue living in the house, typically. Joint tenancy with a right of survivorship. If the house is titled as joint tenancy with rights of survivorship, then the surviving spouse will inherit the house without needing to go to probate court. The decedent's name alone as separate property. If the house is titled in the decedent's name alone, it is considered to be their separate property. The surviving spouse may be entitled to inherit part of it, but probate may be necessary as well. Determining what a surviving spouse is entitled to after the partner passes can be complex. Be sure to consult with an experienced estate planning attorney for legal advice. Thanks.